So this happened. Thursday, federal judge issues arrest warrant for sitting president. Last night, emergency appeal filed. This morning, Supreme Court intervenes. 48 hours. That's all it took. According to court filings made public at 6:47 a.m., Chief Justice John Roberts issued an administrative stay of the arrest warrant pending full Supreme Court review. The 142-page emergency appeal documents just dropped. I've been going through them. You saw the headlines. Here's what they missed. Trump's legal team filed directly with the Supreme Court at 11:23 p.m. Thursday night. Roberts acted within 7 hours, the fastest emergency intervention in modern Supreme Court history involving a president. This isn't a final ruling, it's a pause. But that pause changes everything that was supposed to happen today. Quick context. Donald Trump, 47th president, under federal arrest warrant since Thursday morning. The issue? Whether a sitting president can be arrested under federal warrant while in office, and whether the Supreme Court will intervene to stop it. Timeline, fast version. Thursday, 10:47 a.m., District Judge Richard Holloway issues arrest warrant based on alleged perjury evidence. Thursday, 11:47 a.m., White House files emergency appeal to D.C. Circuit. Thursday, 11:23 p.m., Trump's attorneys bypass Circuit Court, file emergency application directly with Supreme Court. Friday, 6:47 a.m., Chief Justice Roberts issues administrative stay. That's the setup. Now the documents. The emergency application to the Supreme Court argues this is a constitutional crisis requiring immediate intervention. The stay means U.S. Marshals cannot execute the warrant while the court considers the case. Trump's team went over everyone's head straight to the highest court. And Roberts said yes to the temporary pause. Now the question, what happens next? Okay, the evidence. First document, filed Friday morning. I pulled page 8 of Roberts' order. It says, quoting here, upon consideration of the application for stay and the response thereto, the execution of the arrest warrant issued July 23, 2026 is hereby stayed pending further order of this court. That's not my take. That's the Chief Justice. What it means? The warrant still exists, but it can't be enforced while the Supreme Court reviews the constitutional questions. But here's what got me. Page 3 of Trump's emergency application, different section. The legal team argues, no court has ever authorized the arrest of a sitting president. The separation of powers implications are so grave that only this court can resolve them. Put those together, yeah, Roberts agreed. There's a serious enough question to hit pause. I went through the application twice. Pattern's clear. Trump's argument rests on 3 pillars. Presidential immunity from criminal process while in office. Separation of powers violation if judiciary can arrest the executive. Lack of any constitutional mechanism for arresting a sitting president. All documented in the 142-page filing. Now, what nobody's covering. Page 67 contains the government's response, filed at 4:12 a.m. this morning, just 2 hours before Roberts' decision. The Solicitor General argues, presidential immunity does not extend to criminal conduct undertaken in a personal capacity. Perjury is not an official act. Read that again. That's the core divide. Defense says any act during presidency is official, including testimony about prior conduct. Prosecution says lying under oath is personal criminal conduct, not presidential duty. The government's brief cites United States versus Nixon, the 1974 case that forced Nixon to turn over Watergate tapes. Quote from page 73 of the government filing. This court unanimously held that not even the president is above the law. That principle applies with equal force here. But Trump's team anticipated that. Page 89 of their application distinguishes Nixon. That case involved document production, not physical arrest. The difference is constitutional in magnitude. Roberts writes on page 9, this matter presents questions of exceptional gravity concerning the separation of powers and the functioning of our constitutional system. That language, exceptional gravity, appears in Supreme Court orders only when the court believes it must intervene immediately. First time a Chief Justice has stayed an arrest warrant for a sitting president. U.S. Marshals stand down, effective 6:47 a.m. Roberts has authority to issue administrative stays himself, but page 11 indicates he'll refer this to the full court at the earliest practicable time.
If this breakdown's useful, subscribe.
This is moving hour by hour, and I'll be covering every Supreme Court filing, every response, every development as the highest court in the land decides this unprecedented question. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Legal scholars who support the arrest warrant argue this is about basic accountability, not politics. And honestly, some of it holds up. Their argument, first, no one is above the law. If a president can commit perjury without consequence while in office, it creates a lawless executive. Second, the warrant is based on evidence. A federal judge reviewed 14 audio recordings and found probable cause. Third, impeachment isn't enough. Congress can't address criminal conduct the same way courts can. Lawrence Tribe, constitutional law professor at Harvard, put it this way in a statement this morning. Roberts' stay is procedural, not substantive. The court must still rule on the merits. Don't agree with all of it, but that's not nothing. What they've got, United States versus Nixon precedent that presidents aren't above the law. Clinton versus Jones precedent that civil suits can proceed against sitting presidents. Even Neil Katyal, former acting Solicitor General who's been critical of Trump prosecutions in other contexts, admits in a Washington Post op-ed published at 8 a.m., the separation of powers works both ways. Judiciary must be able to check executive criminality. Look, I'm not here to tell you who's right. Defense interpretation, arresting a president destroys the separation of powers and makes the executive subordinate to judiciary. Prosecution interpretation, immunity from arrest makes presidents effectively above the law. Both can be true. That's what makes this complicated. The Constitution provides impeachment as the remedy for presidential misconduct. The founders explicitly debated whether presidents could be prosecuted while in office and left it ambiguous. But the defense raises valid concerns about what happens if every future president faces arrest warrants from politically opposed judges. How can a president function if subject to criminal process during the term? Professor Jonathan Turley, constitutional law expert at George Washington University, wrote at 7:30 a.m., Roberts had no choice. This question is too big for any single judge. That's real. Former Attorney General Pam Bondi, in a Fox News appearance at 8:15 a.m., argued impeachment exists for exactly this reason. Let Congress handle presidential accountability. What I can tell you, what the documents show. And they show Chief Justice Roberts believed the constitutional questions are serious enough to stop this process cold until the full Supreme Court weighs in. This didn't come out of nowhere. Backstory quick. 3 months ago, Trump provides sworn deposition testimony in the documents case. 6 weeks ago, federal investigators obtain audio recordings allegedly contradicting that testimony. 3 days ago, prosecutors file emergency motion with recordings. Yesterday, warrant issued at 10:47 a.m., former White House counsel Ty Cobb predicted weeks ago, if they have him on tape contradicting sworn testimony, this goes to the Supreme Court instantly. What happened? Exactly that. Pattern in presidential legal crises. Watergate ended at Supreme Court with tapes ruling. Clinton impeachment involved Supreme Court precedent on civil suits. Every time, constitutional questions too big for lower courts. The difference now, this isn't about documents or civil suits. This is about whether a sitting president can be physically arrested. No Supreme Court precedent directly answers that. Nixon resigned before facing potential criminal charges. Clinton faced civil suits, not criminal arrest. No president in American history has been under active arrest warrant while in office. Roberts' decision to stay the warrant suggests he knows the court needs to answer this definitively, because whatever they decide becomes the rule for every future president. See where this is going? Like this if you want continued coverage of what could be the most important Supreme Court decision in decades. Friday, 6:47 a.m. Eastern. Here's what happened. Chief Justice Roberts issued the stay from chambers. No oral arguments, no full court conference. The order states, administrative stay granted pending further consideration by the court. What followed? Stay notification to all parties, 6:52 a.m. U.S. Marshals Service stand-down order, 6:58 a.m. White House notified, 7:03 a.m. 16 minutes. That fast. Now, what everyone missed. While people focused on the stay itself, the Solicitor General's brief, filed just hours earlier, contained a bombshell. Page 81 reveals prosecutors offered Trump's team a deal Wednesday. The proffer? Acknowledge the recordings, stipulate to factual inaccuracies in the deposition, accept contempt of court sanction, avoid criminal perjury charges. Trump's response, according to the filing, absolute rejection within 90 minutes. White House counsel's response this morning, immediate statement at 7:34 a.m., calling the stay a vindication. Wasn't reactive, coordinated. You can see it in the messaging. 3 different Trump attorneys gave nearly identical quotes to different networks within minutes. This is where it gets interesting. The stay order's language matters enormously for what comes next. Roberts wrote, pending further consideration, not pending full briefing and argument. That phrasing leaves open whether the court will fast-track this for emergency arguments next week or request full briefing over several weeks. Legal analysts parsing every word. If the court moves fast, we could have a decision within days. If they want full briefing, this could take weeks. Meanwhile, the warrant exists but can't be executed. Constitutional crisis in slow motion. Don't go anywhere. What I show next about the Supreme Court's likely next steps changes how we should think about this. What are experts saying? Former Supreme Court clerk to Justice Scalia, 12 years appellate experience. Roberts' language signals he views this as extraordinarily serious, but not necessarily favoring either side. Plain English, the stay doesn't tell us how the court will rule, just that they're taking over. Another one, Professor Michael McConnell, Stanford constitutional law professor and former federal appellate judge. The court will likely expedite this, but not rush to judgment on questions this fundamental. Key there, fast doesn't mean hasty. Even Erwin Chemerinsky, dean of Berkeley Law and frequent critic of expansive presidential power, admits Roberts was right to stay the warrant. The court must resolve this. When constitutional scholars across the spectrum agree the court should intervene, pay attention. Former acting Solicitor General Neil Katyal broke down the likely timeline. I expect the court to request supplemental briefing by Monday, schedule arguments for next week, and rule by month's end. Lisa Blatt, one of the Supreme Court's most successful advocates with 40-plus arguments. Roberts knows this is Bush versus Gore level stakes. He'll want unanimity if possible. That last point matters enormously. A 5-4 decision either way looks political. A unanimous ruling carries institutional weight. Consensus among Supreme Court practitioners, the court will expedite the process. Oral arguments are likely given the stakes. The ruling will try to establish clear precedent for future cases. What's remarkable, even experts who disagree about the outcome agree about the process. Because next time there's a president accused of criminal conduct, this case is what courts cite. Useful breakdown? Like it. That like button helps this analysis reach people who want to understand what's actually happening at the Supreme Court. Why should you care? Real talk, how this affects actual people? If you're an American citizen, this ruling will define presidential power for generations. The Supreme Court is about to answer, can the president be arrested while in office? Your government about to establish precedent that lasts forever. Not dramatic. This is the foundation of how American government works. Next time you vote for president, the powers and limits of that office are being defined right now. If the court says presidents can't be arrested while in office, future presidents could theoretically commit crimes knowing they're immune until they leave office. If the court says presidents can be arrested, future presidents face the risk of politically motivated prosecution from opposed judges. That's the dilemma every justice is wrestling with. Right now, 3 co-equal branches of government in direct conflict. Executive says you can't arrest the president. Judiciary says no one is above the law. Legislative, watching to see if their impeachment power becomes meaningless. If Trump spends the next weeks or months under the cloud of an enforceable arrest warrant, how does he govern? If you depend on federal government, Social Security, Medicare, federal employee, military family, presidential dysfunction affects you. Whatever the court decides becomes the rule. If they rule presidents can be arrested, every future president faces that risk from political opponents. If they rule presidents can't be arrested, future presidents have immunity from criminal process for 4 to 8 years. Markets dropped 234 points Thursday on the warrant news, recovered 178 points this morning on the stay. If you have retirement savings, investments, economic exposure, constitutional crisis creates volatility. The Supreme Court's legitimacy is on the line. After Dobbs overturning Roe, public trust in the court is at historic lows. How they handle this affects whether Americans believe the court is above politics. Understanding what the court actually decides versus how media characterizes it. That's how citizens evaluate massive constitutional questions. Not panic, information. How'd President Trump respond? Vindication messaging. Immediately. Within 43 minutes of the stay order, Trump posted on Truth Social, total exoneration by Chief Justice. Corrupt judges tried illegal arrest. Supreme Court stopped it. Reaction from legal analysts? The stay isn't exoneration. It's a procedural pause. Roberts didn't rule on the merits, just that the court needs to decide. White House issued formal statement at 8:12 a.m. The Supreme Court has rightfully recognized that this unprecedented action requires the highest court's review. Then Trump's attorney, John Lauro, in a CNN interview at 9 a.m., this stay proves what we've said all along. Arresting a sitting president is constitutionally untenable. Prosecutors' response came at 9:47 a.m. through a Justice Department spokesperson. We respect the Supreme Court's process. The evidence remains strong. Then the latest development, 10:23 a.m., Trump announced he's returning to Washington from Bedminster, calling the stay a complete victory. Not cooling down, escalating the rhetoric. Legal experts note the stay says nothing about the strength of the evidence or the ultimate